People wonder where law comes from. In an obvious sense, law comes from lawmakers. It could be a king, or in a modern context, legislative bodies like the U.S. Congress or the various state legislatures or the city council. But if we dig deeper, we can see that there are several possible sources for the law's authority. So there's natural law theory. On this view, there are principles of right and wrong that are part of the nature of the universe as much as the laws of math or logic or physics. Most natural law theorists argue that God's law is the fundamental underwriting theory of justification for man-made laws. There's also a secular natural law tradition. In either case, the main idea is that legislators are trying to figure out what right and wrong really are and what principles we should live by. To be a valid law on this view is to conform with the natural law. An unjust law, then, isn't really a law. One example would be in the Declaration of Independence, they declared their rebellion against the royal authorities on the grounds that it was no longer morally binding on them. Similarly, in the civil rights movement, the argument was that the segregation laws, being manifestly unjust abrogations of human nature, were meant to be violated because they could not be seen as binding on the conscience. There's also an idea that there's no such thing as natural law, that the natural law theory is entirely disconnected from political realities of laws and lawmaking. This is known as legal positivism. On this view, the laws are whatever the lawmakers say, and a law will be valid just in case it's procedurally valid. For example, in federal law in the United States, if it was passed by both houses of the legislature and signed by the executive, then it's the law, provided, of course, that it's not found to be unconstitutional by the judicial branch. In the positivist tradition, law is disconnected from considerations of morality. As long as the law has been passed in proper procedural form, then that makes it valid. For example, in Nazi Germany, all of the laws pertaining to the extermination of Jews and the rounding up of undesirables for the concentration camps were consistent with German law at the time. So what they did was not illegal in any positivist sense of the word. And in the United States, prior to the 1860s, slavery was entirely legal. So if a slave escaped to the North, the law required that the slave be returned. And there's another sense of law which doesn't even involve kings or politicians. In the evolution of many societies, we see the development of law in what could be seen as an organic process. All societies will need to discover ways of living and working together, so it makes sense that they would develop rules for regulating their interactions with each other. This might seem like random trial and error, but it's actually an evolutionary process that yields stable but also flexible and gradually changing procedures which are like laws for those communities. The English common law and customary law, the international merchant law that developed in the Middle Ages, these are some examples of this process in action. What counts as validity in this model is the extent to which the rules actually do facilitate social interaction and accord with people's general sensibilities about right and wrong and efficiency. Understanding law as an evolutionary process is probably the best way to make sure that on the one hand we have stable rules that people can understand and use to coordinate their behavior, but at the same time provide for flexibility and individuality and cultural pluralism. A system like this is generally more conducive to freedom than more authoritarian top-down systems.